Once a child support order has been issued by the court, can either party ever modify the order, the terms, and the amount?
So the short answer to your question is yes, you can modify a prior order of child support. With that said, every case is fact specific. So just because one person was able to modify their prior child support order doesn't necessarily mean that you can or everybody can. So again, in New York specifically, there are typically three circumstances in which you have the right to petition the court for a modification. And the modification can be for either an increase in the amount or a decrease in the amount. It depends, obviously which spouse is petitioning. Is it the payer spouse, the payee spouse, and on what basis? So generally the three situations that the court allows is either there's a change in circumstances. So for example, when the parties entered into the stipulation of settlement and got divorced, the children were very young. So they didn't account for things like college expenses or SAT prep courses or certain extracurriculars. And while there's no statutory right to those things, any party can petition the court and the court can grant those things, again, on a case-by-case basis. The second situation that you typically see a court allow modification for is if there's been a 3-year time lapse since the entry of the initial order, because people's incomes obviously go up, go down. So, either party can then say it's been 3 years. I don't know what, my ex-spouse currently earns. I believe it's more or less, whatever it may be, and I would like to recalculate support. The last is when the paying party wants to decrease the amount, and this would be based on a 15% decrease in their income, which is involuntary. So in other words, even if somebody got fired from their job, let's say, they still have to do everything in their power to secure employment that's commensurate with their experience and what they were earning. So it's not enough to say, I'm going to quit my job today, or I was fired, and I'm going to take a job that makes, I earn significantly less, maybe half my income, and then I'm going to go to court and say, listen, I only earn half my income now, so my child support should be half the amount. Obviously, courts are, wary to that situation. So, in an effort to avoid it, the statute is very clear that it has to be involuntary, and you have to show active efforts of, trying to secure employment to, earn the same amount of income that you were earning when the order was issued.
So a 3-year waiting period. You can't just leave court and say, I'm filing for a petition immediately.
So you can if there's a change in circumstances, or if there's a 15% decrease in the income. So there's, a couple of different ways. And sometimes it's been 3 years and there's a 15% decrease, or it's been 3 years and there's a substantial change in circumstances. It all depends, on being fact specific. So it doesn't necessarily have to be the 3-year waiting period, but if it's not, then there has to be a substantial change in circumstances.
And is that process, that's something that somebody needed to do, is the first step, I've got to talk to a lawyer? Can they handle it on their own?
So I always recommend at least consulting with an attorney. Child support is definitely one of the more straightforward categories in this type of law, but if the other side has an attorney, then you definitely want an attorney, because you didn't go to law school. You want to be on an even playing field. And if you're going to have a hearing, you're likely going to be unfamiliar with, the evidentiary rules and, how to present your case. And so if you are on the right side of things and you have all of your paperwork, but you don't know how to, get it into evidence, and the other side has an attorney and they can, then, you're obviously going to be prejudice. So, it's almost like, why risk it? You're going this far, you're going to court anyways. Do you want to risk coming out with an unfavorable outcome just because you're not on an even playing field as a pro se litigant? You have to kind of do a cost benefit analysis and,
Right.
decide what makes most sense for you at that time.
Right. Yeah, it's like you said, cost benefit, trying to get a $50 increase in child support might not be.
Exactly. If you're asking, if you're an attorney's charging $5,000 for you to get a $50 fee, well, then is that worth it to you?
Right. Exactly.
But there's also certain situations where you can also petition the court to have your ex-spouse be responsible for your legal fees. So let's say there's terms in the agreement that were then merged into the judgment of divorce, and it says, for example, dad has to pay $1,000 a month on the first of each month for child support, and dad is not paying that amount. Well, then what can you do? You can go to the court and you can file a petition and you can seek that the court find him in contempt of court. He's violating a court order. And then, along with that, you can also request in your petition that since you're being forced to go to court and petition the court for his violation of the order, you're also seeking an award of counsel fees.
Lauren, this was fantastic, really helpful answers to people's questions. Tell people what's the best way that they can find you.
They can either reach me by phone. My number is 516-605-0507, or they can email me. My email is my first name, Lauren, at lfrlawpc.com. And thank you so much again for having me, Rob. This was just a great time. And I look forward to hopefully doing this again with you soon.